Hello and welcome to TMS Insights. I'm James Diegelman, a private wealth advisor at TMS Capital. And today we've got a very special episode of Insights where we're going to discuss estate planning. So estate planning is complex. It requires specialist advice. So I've got Anthea McIntyre with me today, and we're going to discuss some common questions that clients will ask us during our meetings. Anthea has 20 years experience as a solicitor? Yeah, 20 years experience, and is the principal at McIntyre Legal, where they are experts on wills and estates. So Anthea, thank you for coming.
Thank you for having me, James.
We'll start by asking, why should everyone have a will?
Well, look, you spend most of your life trying to build up your wealth and your assets. You want to have a say in where they go when you die. And if you don't have a will in place, your estate is otherwise divided up according to a statutory formula set out in legislation. So most people want to make sure that in the event of their demise, their assets are going to pass to the people they love in the way that they decide. And otherwise, you've got young children potentially missing out or receiving an inheritance at a very young age, and you're then having your assets divided up according to a statutory formula. So you have no control over it if you don't have a will in place.
Okay, yeah, very important. And so if you've already got a will in place, is there a trigger or is there a time where you should be reviewing your will?
It's generally a good idea to review your will every 3 years so that you can ensure that the executors you've nominated in your will still are people that you wish to have in control of your estate when you die. Certainly if you've got children, it's important to review any guardianship appointments in your will. And I think just it's good practice to just reflect on your will, make sure you're dividing up your estate as you would like to. Every 3 years is a general guide.
Okay, great.
If there's a death in the family or any new assets that you acquire.
Or changing marriage or...
Yes, yeah. If you marry, divorce, separate in a de facto relationship context, have more children, or one of your executors dies or guardians dies, it's generally a good idea to update your will.
Yeah, excellent. And there is quite a complex part of wills when there's a blended family or a remarriage has happened in the family. What are some of the challenges that they face when doing their estate planning?
When it comes to a blended family, which we generally use as a way of describing where you've got perhaps children to a prior marriage and then children to a second marriage. Sometimes there's no children to the second marriage, but there's children to a prior marriage. And normally the person making the will, called the testator, wants to make sure that the children to the prior marriage are well looked after, as well as the new spouse. In some scenarios, there are clients who don't wish to make provision for the children in the prior marriage. Perhaps there's been a breakdown in the relationship or years of estrangement. Nevertheless, it's really important to get advice about your estate planning, because even if you don't make provision for those children, they can challenge your estate when you die. Most children, no matter how old they are, will have some expectations around receiving inheritance when their parent passes away. Yep. And so we want to the extent we can, try and minimise the risk of litigation. We want to try and preserve relationships with step-parents and avoid expensive, stressful, hurtful, painful litigation. And so it's important to get advice from an experienced estate planning lawyer who can give you advice about the ways in which you can divide your estate to hopefully keep everybody happy. Yep. And minimise the risk of litigation in a blended family.
And do you usually meet with the client one-on-one then, or do you get the family involved?
No, always. We only ever meet with the testator.
Yep.
I don't ever meet with the children. Generally, it's important that it's the client making the decisions. Sometimes if you bring the children in the mix, you'll have 7 different opinions, too many cooks in the kitchen. Yep. So we have our meetings just with the testators. If they wish to consult with their children, they're free to do so. But sometimes that can just bring in more stress for the family, for the testators who are already struggling with how they're going to keep everybody happy. These are confidential documents. They're private. Generally speaking, it's best to keep them that way. Otherwise, you're just going to have people voicing their opinions on what you've tried to do as best you can in a document with the benefit of legal advice. Some circumstances, particularly if there's companies or there's family trusts, you might involve children in the discussion.
Of a transfer situation.
But when you're making a will, you also want to make sure that will's valid. And that means it's not been, the content of the will has not been, hasn't had other people influencing your decisions, that there can be no allegations made around undue influence or lack of knowledge and approval on your part about the contents of the will. So it's really important that that will reflects your wishes, and that, you know, your spouse does a will as well reflecting their wishes.
Okay, excellent. And what about testamentary trust? Do you recommend that people use a testamentary trust?
The question of whether you wish to include a testamentary trust in your will, essentially giving your beneficiaries the option of receiving their inheritance rather than as a direct gift to them, to give them the option of receiving it in a testamentary trust, really depends on a whole range of factors. One is the size of the gift that you're giving the beneficiary. If you're giving them, say, a sum of money or an asset valued at $500,000 or more, that's when you start looking at potentially, would a testamentary trust be beneficial for that beneficiary? And so in that scenario, of course, some people want to keep their estate their wills very simple, in which case we wouldn't include testamentary trusts because it does go from a 10-page will to a 30-page will. But testamentary trusts carry significant benefits for the beneficiaries, or potential significant benefits in the form of tax benefits. So it gives your beneficiary the opportunity to receive their inheritance in a testamentary trust, invest the inheritance in the way they otherwise would, but then make distributions of any income to people on lower tax thresholds. So the common scenario you might see is mum and dad making a will, 2 children, who one day are going to have children of their own. So if we're going to make a will, we might give each other the option of having a testamentary trust so that I can then receive inheritance from you when you die. Do you see how I made you die first, James? You're going to die. I'm going to receive all your money.
Take all the money.
I like that. I'm going to put it in a testamentary trust, invest the capital that you've given me, generate income, and it might be in the form of rental income, dividends on shares, interest in a fixed term deposit, whatever the income is. Because I'm already earning income at a higher tax threshold, I would choose to distribute the income instead to our minor children. And those minor children don't have any other sources of income because they're still at school. And so we can make the most of their lower tax thresholds.
So they can get the 18,500 tax-free.
18,200 at the moment for tax-free, and then between 18,201 all the way up to 45,000, they only pay 19 cents in the dollar. Much better than the higher tax threshold of, the 45 cents if you're in the higher tax bracket. So yes, it's the opportunity for me to receive the inheritance, put it in a testamentary trust, generate income, and distribute the income to the children. And I would use it to pay private school fees, university fees, food, medical expenses, whatever I see the children might need. And then on my demise, my children can also have the testamentary trusts. And these trusts last for 80 years. So the children can then use the money that they've received as an inheritance to generate income once again and distribute it to their children. Now, with these testamentary trusts, you can make these distributions to minor children. You can't normally do that with a trust you create during your lifetime. It's only a trust created on death under a will that you can make these distributions in a tax-effective manner to a minor child. The other main reason people include testamentary trusts in their wills is because of the asset protection benefits that can come with a testamentary trust. So in that scenario, again, of you passing away, I receiving your inheritance, if I was going through bankruptcy, all of that money would then go to the trustee in bankruptcy. Exactly. If instead it came to me in a testamentary trust, it doesn't form part of my assets that I have in my personal name, and the will would provide some protection for that inheritance. Similarly, if I was to then go in after a decade of mourning, James, go and re-partner, if I had all of the money just sitting in my personal name and I entered into a new relationship, it would form part of the marital pool of assets. Whereas instead, if I keep that inheritance in a testamentary trust, it's not going to necessarily form part of that marital pool of assets with a future spouse. Similarly, for a parent, when we're transferring wealth to the next generation, we want to make sure, to the extent we can, that the money we give to our children isn't at risk of just being lost in a relationship breakdown for our children, or if any of them become lawyers, doctors, entrepreneurs and lose their inheritance. So it's a way of, as best we can, still giving the children control over their inheritance, but putting in some mechanisms to provide some potential asset protection benefits.
Great.
We can achieve that with a will with testamentary trusts in it.
And who would be the trustee? Who would control that trust?
You get to nominate that in your will.
Mm-hmm.
Typically, the person you nominate as your executor would then also be the trustee.
Yep.
So in the scenario that we described earlier, if you passed away, I would have in your will that I was your executor, and vice versa. And then in the event that we both died, we'd then nominate, perhaps because our children are minors, we'd have then some trusted friends or perhaps some siblings.
Yep.
But when you're choosing that executor, you must make sure you have somebody who you trust without reservations, because they will have control over your whole estate, and they'll be making decisions in the best interests of your children, if that's how you're leaving your money.
Yep.
And so typically you might have a sibling, a spouse, trusted friends, but people who you trust their judgment,
Yep.
and you know that they're financially stable in their own
Themselves.
rights.
Yeah.
Exactly. And you can have some numbers of options. So it might be, you might have your mum. If not, you might spouse. Then you might have your mum or your dad. You might have a sibling. You might have a friend.
Yep.
You can have some a few options there.
According to the will, it would just go through next.
Exactly. So if someone doesn't wish to take on the role, or
Yep.
they've passed away, then the next nominated executor can then step up to the role.
Great, interesting. And one of the other questions that we get asked about is enduring power of attorney and enduring guardianship. So a lot of the responses that we get when we ask our clients, do you have these in place, is they think, oh, that's what you do when you're further down the line, that's too far away for me to think of now. First of all, what are those two documents, and when should they be put in place?
Yeah, great questions. An enduring power of attorney is somebody who is appointed as your attorney to make financial and legal decisions at a time you determine. And most people, the word enduring means it endures beyond loss of capacity. So you would appoint someone as your attorney now, and then if you lost capacity, that their power would endure beyond loss of capacity.
Yep.
Most people, when they're preparing an enduring power of attorney, will elect for it to only commence on loss of capacity, which we can spend a long time talking about when that happens.
Yep.
But it's very important to have someone appointed as your attorney. And it's, as you alluded to, it's not just when you're old that you can lose capacity. Sadly, we see clients who are going through cancer treatment,
Yep.
who in their 30s pretty quickly lose capacity, involved in a car accident. You lose capacity potentially. So it is important for any adult who has assets, particularly if you're a director of a company or if you've got a self-managed super fund, if you lost capacity, even if it's for a short period of time, someone needs to be able to step into your shoes to manage your bank accounts, make sure there's still food on the table, pay medical expenses, lodge tax returns, run any companies. It's very important to have someone acting as an attorney. If you don't appoint an attorney, then somebody will need to make an application to the Supreme Court or to the Guardianship Division of the New South Wales Civil and Administrative Tribunal to be appointed as your financial manager. It's a whole heap of complexities and costs and stress involved in that.
And you don't know who's ultimately got control.
That's right. It's up to the court and the tribunal to then appoint somebody on your behalf, and that person appointed as financial manager then has to lodge a whole range of documents with the New South Wales trustee and guardian.
Yep.
So the enduring guardian, the second document that you referred to, is somebody appointed to make medical decisions and accommodation decisions. So in New South Wales, we have two documents: an attorney to make legal and financial decisions, and the enduring guardian for make medical and accommodation decisions. For many clients, it's really important for them to have in place an appointment of enduring guardian, somebody that they trust to make decisions for them around their accommodation, to consent to medical treatment, to refuse medical treatment, to make the decisions about when we cease treatment.
Yep.
For me, it's a very important document. If you have particular strong views around nursing homes or where you want to be cared for in your later years. But once again, it's not just your later years, as we were referring to earlier. It could be medical treatment at a young age, it could be a car accident. You need somebody to be able to make medical decisions. So commonly people will appoint their spouse and alternatively perhaps parents or siblings, but there is no default position at law that your spouse can step into these roles as attorney or guardian.
Okay, that's
you
interesting,
must
because
appoint
you would
them.
think that that's naturally what would happen.
Not everybody likes their spouses,
Yep.
and the law doesn't. I mean, many people separate, of course. So there's
Yep.
probably a good reason that we don't have these default positions.
Yep.
But it's very important to have these documents in place, and also to, like your wills, review them every 3 years to make sure the people you've nominated.
Is who you want.
Yeah, exactly.
Wonderful.
Yeah.
All right, Anthea, well, thank you very much for answering those questions for us. It's been great and it's been entertaining. And of course, if there's anyone out there listening who would like to learn more or you've got some further questions, please reach out to your advisor at TMS Capital and we can put you in touch with a specialist.